The first matter is Jonathan Peters versus the Workers' Compensation Appeal Board, Cintas Corporation. Representing Jonathan Peters is attorney Daniel J. Siegel. Representing appellee Cintas Corporation is attorney Kathleen C. Pochettino.
Good morning, everyone. We welcome all of you to our September session, held as in May remotely in light of the continuing public health guidance. Council, I think, have been fully briefed on the protocol for this session. I'll remind everyone, as I think Brian had, that I'd appreciate a minute to frame the issues in the cases that will be argued today, and then we'll turn to each council in turn for opening statements. I would also ask you, as the justices have an opportunity to pose questions to council, that you endeavor, in light of the remote aspects of this, to focus your attention on the justice asking the question. And as always, remember that we have access to your briefs so that we're fully cognizant of all the issues, in most instances, a discrete issue. The first case has been called, and this is a workers' compensation case in which a claimant is a sales representative who was required to travel for work. After being injured in a motor vehicle accident, the claimant sought workers' compensation benefits. The case presents a unique factual scenario which may aid in clarifying the circumstances in which a traveling employee will be deemed to be acting within the scope of his employment, thus entitling him to benefits. Mr. Siegel.
Good morning, members of the court. May it please the court. I'm Dan Siegel on behalf of Jonathan Peters. Also present with me is Alexis Berg, who had handled the matter in the lower courts. This case is somewhat unusual and also somewhat not unusual in the sense that dealing with traveling employees, as Your Honor indicated, do not have a fixed place of work, is a very common situation in Pennsylvania and throughout the country. This court has never had the opportunity to determine the standards, however, until this case, for traveling employees in terms of what is the definition of a traveling employee, what are the standards that apply to determine what is a compensable injury. Traveling employees are somewhat unique in the sense that, unlike typical workers who work from a location and can suffer an injury, traveling employees are those employees without a fixed place of business. And the standards that have been applied to this time by the Commonwealth Court have all focused on the fact that once an employee who is a traveling employee begins his or her travels, that entire process continues and is furthering the employer's business activities, whether they are a traveling salesman, someone who has to travel out of town, etc. This case presents the situation where an employee was injured on his way home from a social event and allows this court, as per the questions that have been raised, as to what constitutes abandonment of employment. What we have done and what we have proposed to this court are essentially three concurrent standards that would create a consistent analysis, whether in this particular case or in any other case involving traveling employees. We suggest that the court first define traveling employees as any employee who has to travel from place to place, away from typically a permanent residence or the employer's place of business, when such traveling employees would include from when they begin their trip until they arrive home, unless there is what has been called an abandonment of employment. And that's really the central issue here. We propose that and consistent with many of the Commonwealth Court's cases, that abandonment of employment would have to be a distinct break from the activities that would be done by the employee, as opposed to temporary departures for anticipated things such as personal comforts, non-employment related events, and also where you are attending an employer-sponsored event, whether voluntary or not. And then, as has been applied typically in the Commonwealth Court and in other jurisdictions, as set out in Judge Jubilier's dissent in the Commonwealth Court, an employer would have the opportunity to rebut the presumption that it's work-related by demonstrating that it was such a break in the activity as to remove the employee from the course of employment.
Counsel, This is Justice Baer. Let's assume for right now that your client was a traveling employee. I think the initial question is whether he should gain advantage of the presumption. And it seemed to me, and it was difficult to discern. As you say, there's none of our cases, and the cases are sort of everywhere. But at least as I perceived your opponent's brief, that the underlying purpose of the doctrine was when the employee was deceased and could not testify to their motivations, the presumption arose out of fairness to them because they were traveling. Here, your employee survived and is able to testify that I was not going home, that I felt obligated to go to this party, or conversely, that I just felt like going to get a drink, which obviously he's not going to say or we wouldn't be here. So does the presumption make any sense when the employee is free to go defend himself with counsel at the hearing?
No, Your Honor. The traveling employee doctrine should apply regardless whether it is a fatal claim or a claim such as this. The rationale behind that is when travel is an essential part of the employment, such as in this case for a salesman, the risk of injury, of being injured, whether in whatever means, is incident to that employment. And as long as the employee is still within the continuum of performing or on the travel for the employer, it should apply. We don't believe that the standard or the suggestion that it must be a fatal claim is appropriate. There's no such suggestion in the Act, and in fact, Section 301 of the Act specifies that injuries can occur off premises and makes no distinction. Moreover, to accept the employer's arguments, this court would also be vitiating the traveling employee doctrine and creating the test that applies to an office-based employee, which is simply furtherance of an employer's business. When courts have looked at, primarily the Commonwealth Court, that standard, they have determined that while you're in the continuum of being a traveling employee, all of those activities are furthering the employer's business unless there is such a break as to contact.
Can I follow up for a second? Did you, well, you or your colleague who's with you represented the claimant at the WCJ and WCAB. Is that accurate?
Yes.
Well, I noted that neither of their opinions got into the traveling employee or continuing work presumption. I thought that was interesting because we presume that they have greater expertise in this matter than does our court or the Commonwealth Court. Do you have any insight? Was it not raised? Did you not raise it? Did the other side not raise it? Did they conspicuously reject it? But what happened here that neither of those tribunals opined to it?
Well, if you look at the appendix of page 10, you will see that the workers' compensation judge in his findings of fact said, and I'll quote, "It is acknowledged that claimant is considered a traveling employee and therefore consideration is given to that presumption, et cetera, et cetera." the WCAB also acknowledged that he was a traveling employee, as did Commonwealth Court. That was the central distinction. The problem was that there was an analysis done that primarily looked at social event cases rather than traveling employee cases. But clearly, when you look at the matter before the WCJ, as I quoted, acknowledged that he was considered a traveling employee. That was not in dispute.
When I started my first question, I said, let's assume for our purposes he's a traveling employee. Yeah. The issue of whether he gets the presumption is discrete from that. He could be, as I posited, and I'm asking because I don't know. I mean, I'm not trying to badger you. He could be a traveling employee, not deceased because of this accident, thank goodness, and therefore not entitled to the presumption. Or conversely, a deceased traveling employee, a little bit like the dead man's rule, who, because he's deceased and can't testify, well, I felt obligated to go to the party. I drove by my exit because I was trying to get there as fast as I could, and on and on and on. So because you arguably just get into a credibility determination in whether this is a frolic or detour or a continuation of work, you don't need a presumption. But it's the last time I'll ask you, but again, I think it's the central point of the case.
Well, I think the presumption should apply, and that's the test that we propose to the court, that the presumption applies and then may be rebutted, because as much as you can have a test, it will always come down to a determination by the judge as the fact finder whether whether an employer has rebutted that presumption, whether the evidence is sufficient. But the distinction between whether an employee lives or dies is a distinction that is not consistent with any of the case law or any other states that have addressed this. They look at it as the employee once, suppose I'm a traveling salesman, once I leave my house today to go on my route and stop at the different businesses, I am still presumed to be the traveling employee until I get home and end my route. Now, if during that time I decide to abscond and go to a motel with someone or something like that, that's a discrete break from the work that would presumably be the rebuttal that the employer would present. But
Mr. Siegel, it's Justice Todd.
Yes.
It seems to me that referring to where this traveling employee was headed as a party and as making him have a break in his employment does not make sense in a situation where, as here, the employer was, in a sense, sponsoring the social gathering, providing, paying for a drink, providing and paying for appetizers. Isn't there a true distinction there that distinguishes this case from any case where, a guy just stops for a drink?
Yes, Your Honor. That's the point. In this particular case, and while there's been a lot of discussion about whether it's voluntary or involuntary, the dissent addresses it well in the Commonwealth Court, that he went to an event that was an employer event. Whether it was mandatory or not, the supervisor was there. He went directly from work. The company paid for all of the refreshments, food, drink, whatever was used on a company credit card. And from there, he began his travels home when he got into the accident. That's all within the continuum, sort of the reasonable continuum that has always been done. What's happened here is that a standard was added essentially by Commonwealth Court that said he passed his exit for his house. Well, if he had not passed the exit because he lived 20 miles further, theoretically it would have been compensable. That's not a distinction that has any sort of rational basis.
Mr. Siegel, maybe I'm not quite understanding this, but in terms of the Commonwealth Court's analysis regarding the exit for his house that he passed, but let's say hypothetically that the employee did go home, did stop at his house, changed his clothes, and then went out to an employer-sponsored event, such as the one we're talking about here. I'm not sure I understand why that would make a difference. It's still not an abandonment, is it?
I don't believe it is. It's no different than if he did that at work. Well, I'm done my day of work, so I'm going to take my suit off, put on a sweater and some khakis. I don't believe that takes him as a break from employment that is discrete and distinct, as opposed to the example I gave or many others we could create. I agree.
Even if it is a break in the employment, or a break in his continuum, rather, doesn't the continuum arise again? Doesn't the working relationship arise again if he is independently then changing his clothes? Okay, that segment of my day was over, but now I'm doing another work-related event.
Yes, it does. I agree.
Counsel, this is Justice Doherty. Now, you indicated that the employer paid for all the drinks, but my understanding of the record was that the employer only paid for one drink as well as the appetizers. Assuming that the employer only paid for one drink and left, and your client remained, do you find that to be a distinction such that he abandoned the work since he now has left or remained at a bar separate and apart from, as what Justice Todd calls a work function?
No, I don't. The fact that whether he stayed or not is not a factor here. He was at the work event in his course of his work and then proceeded home. Whether he stayed for a drink or anything else does not constitute a break, and certainly wouldn't be an abandonment of his employment, which has traditionally been viewed as something very distinct and separate, and that's not the case here.
Counsel, it's Justice Donahue. Could you do me a favor and tell me what the result here would be in the facts most favorable to you, an employee-initiated event, if the employee was not a traveling employee, but instead went across the street to the social gathering and then went home and was in an accident? If
this were not a traveling employee, and he or she is injured at the event, that is compensable. But if they're not a traveling employee, they are subject to what's been called the coming and going rule, which essentially is an injury is not compensable while commuting. So that injury would not. And that's consistent with...
That's where the presumption comes in, does it not? That's where the presumption plays its most critical role. The presumption takes the employee who's a traveling employee back to his home before his workday is concluded. Am I understanding that correctly?
Yes. The presumption is different and essentially more extended because of the nature of the employment as a traveling employee. Yes or no?
So it gets him back home?
Yes, but not the person who just goes to their computer.
Correct.
Counsel, question, a follow-up. Would a remand be necessary to explore what went on after Smith and Cintrone left, after the tab was paid and they left and your client stuck around? The record doesn't seem to speak to what was going on, and perhaps that lacuna there informed the lower court's finding that of abandonment. Would there come a point in time that a traveling employee staying on at a bar, drinking a few more rounds, for example, or even going to some other bar and having a couple more drinks would break the chain here?
Well, I don't believe a remand is necessary. There was an ample factual record developed by counsel on both parties as to what happened, from which the judge made the workers' compensation judge made findings. There's simply nothing in the record presented by anyone that evidences an abandonment or other conduct that would take this out of the continuum of a traveling employee. I don't believe you need to remand. I believe it would be a reversal here for an award of benefits.
Mr. Siegel, Justice Todd again.
Yes.
Following up on Justice Weck's question, would you agree that in that hypothetical scenario where all the work colleagues left, the boss left, the tab was paid, and the employee stayed another hour or so and became inebriated, that there is a break in the continuum?
It is possible, depending on the facts, yes, but those facts aren't here.
I understand. That's why I said hypothetically, but
Yes.
I'm just trying to see, will you acknowledge that there can be a break midway through the work-related activity?
Oh, there could be. I mean, and both parties' briefs highlight all the different cases with all the different types of breaks and events that could happen. This is far more traditional that, there's an employer event, the employee goes to it, and then from there, he goes home. This is almost the simplest scenario because we don't have all of those what ifs of the types of things that would make all of us say, well, maybe. There's nothing here that creates that maybe or that concern of a break or abandonment.
Mr. Siegel, Justice Baer, and again, I'm following up on Justice Wecht and Justice Todd. And I don't typically like to do this because we're getting into the facts. And we're a court that tries to establish legal tests. But, and again, I come back to where I sort of began after I prepared. Your client's alive. Your client testifies with counsel. The WCJ, listening to the stories of all as to when your client arrived, when the employer client supervisors left the bar, which I think was 45 minutes or so before your clients arrived, how long your client stayed, et cetera, makes the factual determination that your client was there, not improperly, but having a personal drink with some friends, watching Monday Night Football, and not there for the work program. The WCJ surely has the right to do that on contested facts. Does that then overcome the presumption?
I don't believe it does here.
Okay.
What I have here is a situation where he's still within that continuum. And what happened here more so is that the WCJ did not properly apply the law, or the law as we are suggesting this court should clarify, to these facts, but that the facts remain of the type that there was no abandonment of employment. There was no discrete break that took him out of anything that would be foreseeable. People go to restaurants and bars all the time, and in social gatherings, they don't typically everyone leave at the same time. Some linger, some talk. And that's part of the desire often of an employer that you build a collegiality, or that someone's just resting. If he had a long day, he might want to rest and watch a game, but it doesn't constitute a break.
Counsel, can I ask how you would like us to define the type of event that's necessary in order to have the continuum of employment? Either you or one of the amici refer to an employer-initiated social event. Does that aptly describe the context of the type of gathering that would qualify as not an abandonment?
Yes, so, it would not be an abandonment. The distinction.
Employee-initiated social event.
Okay, and if it's employer
Employer initiated. I'm sorry.
Yes.
Thank you for correcting me. An employer initiated social event. Does that aptly capture the situation we're talking about?
Yes, that's this situation here. And that's what we had here. It's very different from if, let's say, I and 3 colleagues decide at the end of the day we want to go out and have a drink or go, for dinner. That's not an employer's event.
I understand that, but I'm trying to capture the appropriate description. An employer-initiated social event has nothing to do with voluntariness or involuntariness. It's the fact that the employer initiated the event that is the critical point.
Yes, Your Honor.
Mr. Siegel, it seems to me that standard that Justice Donahue is asking you about is really a substandard of what Judge Cohn-Jubileer said in her dissent, and she restated the well-used, well-understood standard that the employee's actions were so foreign to and removed from his usual employment that they constitute an abandonment of that employment. Is that the standard that we're still applying?
I would suggest yes. I believe the dissent was correct. And had it been the majority, we would not obviously have sought aliquotter.
Thank you, Mr. Siegel. We'll hear now, please, from counsel for the appellant or the appellee, Ms. Pochettino.
Good morning. May it please the court. My name is Kathleen Pochettino, and I am here on behalf of the appellee, Cintas Corporation. I want to kind of phrase the discussion in reading a book. We start at chapter 1 of a book. We start at the first chapter. The first chapter of this book is section 301C1 of the Workers' Compensation Act. And that provides that for an employee to be in the course and scope of employment, they must be in furtherance of the employer's business or affairs. Starting our analysis and our discussion as to whether or not the appellant was a traveling employee is starting our book at chapter 6. The Workers' Compensation Act is always where we start our analysis in these cases. And that's why the WCJ and the WCAB started their analysis there. What was the appellant doing at the time of the injury? What was the incident that gave rise to that accident? Here, he was commuting between a non-mandatory social event. And I think to call it employee-sponsored is just another way of saying that the employer-sponsored was that the employer paid the tab. The facts that were found by the WCJ was that this was not mandatory. It was voluntary. It was a business meet. It was not a business meeting. It was a gathering for chit chat and to wind down at the end of the week. When you take those facts into consideration and starting at section 301C1 of the Workers' Compensation Act, you get to the conclusion that he was outside the course and scope of employment. Looking at the case law that defines and describes that section of the Act, you see that the court has come up with various descriptive terms. But ultimately, at the heart of it is whether the appellant was in furtherance of the employer's business or affairs. Commuting or driving home from a social event is not within the course and scope of employment.
Counsel, I'm sorry, are you done with your summation? I don't have 2 minutes. No. The difficulty, and I wanted to see if I could direct you, Justice Baer, is that you're arguing the facts of the case. That's really not our court's function. We're interested in whether we should, in fact, adopt the presumption, whether the presumption is applicable here, whether the presumption controls notwithstanding the facts here. Just wondered if you could turn your attention to that and not ask us to get in the question of whether or not the WCJ, WCAB, or Commonwealth Court erred in terms of their factual findings.
So the analysis, and Justice Barry, you asked this of Attorney Siegel, why did the WCJ and the WCAB have a different focus in their opinion from the Commonwealth Court? And I think that that's the heart of this case. You don't get to the presumption that someone is a traveling employee until you make a determination as to the facts surrounding the incident. There is no 24-hour continuum that once you leave your house for work that you're continuing working. And you can see that in the cases that discuss business trips, out-of-town business trips. So for that presumption of the traveling employee to apply, there has to be first a determination as to course and scope of employment. And it comes back to Section 301 of the Act. So he was commuting. He wasn't working. He wasn't driving from a meeting. He wasn't driving from a business meeting. He wasn't driving from a sales call. He was commuting from a social event. And that goes back to the coming and going rule, which excluded commuting. And in reading the cases and in using the term traveling employee or abandonment of employment, I think they're just buzzwords or descriptive terms to get really to what the heart of the issue is in furtherance of the employer's business or affairs. Commuting event is not in furtherance of the employer's business or affairs.
So can I take, this is Justice Barry again, so can I take it from your considered view of the case that if we decide that upon reading very carefully, which has to await post-argument, the record in this case, that he was under some compulsion, even informal compulsion, to attend the event because he was invited by a superior. And I don't know your situation, but you're in a big law firm, and your senior most partner says, well, why don't we go have a drink tonight? And you don't feel free to say no to that, even though you didn't want to especially go. So you go. So he was in that kind of scenario. If we decide that, then you would concede that you don't prevail in the case. Your whole argument is that the coming and going rule is applicable and that he was out with buddies for a drink that had nothing to do with work. Is that correct?
Yeah, he was driving. Yeah, he was driving home, and it had nothing to do with work.
Fair enough. Thank you.
Counsel, it's Justice Donahue. Can I follow up on that? You would then argue against this court holding that an activity that is in further of building good relationships between the employer and employees is in furtherance of the interests of the employer and therefore within the scope.
So the WCJ noted in his opinion that there is a separate line of cases related to those social events that can be found to be work-related. The WCJ references the Tredifferent case.
And Kelso is also one of those cases.
Right.
Kelso is also one of those cases. Do you agree or disagree with that proposition?
I'm sorry, I couldn't understand what case you said.
Kelso, and the case that you cited, the notion that if the activity is in furtherance of good relationships and, promoting a good, healthy workplace, that is within the furtherance of the interests of the employee and is within the scope.
Correct, but that's a factual determination that the WCJ makes as to whether that social event is work-related. And
you're stating it differently. I mean, if we say that if an event is sponsored by the employer and its end is to promote good relationships between the employer and the employee in a good workplace, then the workers' compensation judge would have been wrong. This was initiated by the employer, was it not?
Mr. Cintron, the manager at the time, did invite the other employees to gather at the Tilted Kilt on this afternoon, on that evening. That is correct. But in making a determination as to whether a social event is work-related, there's a multifactorial sort of indicia test in the underlying cases that make that determination. And those cases that find work-related injuries at social events are injuries that occur actually at the event. And Mr. Siegel commented on that, noting that only those injuries that occur actually at the social event are within the course and scope of employment and not necessarily.
But counsel, that's why there's a presumption for traveling employees that they're working until they get home at the end of whatever the day encompasses, including an employer-sponsored social event, or I should say an employer-initiated social event. That's where the presumption comes in, getting back to Justice Bear's questions.
Presumption should only apply when someone is in furtherance of the employer's business or affairs. So
okay. I understand your point. Thank you.
Thank you. Could I just ask a question? What in the world does it have to do that you get to this event? He drove past the exit to his home.
That was determinative for the Commonwealth Court as to
how could that even be a factor? What would that have to do with anything? If it's assuming it's an employee event, you have to get there past the exit to his home.
So the Commonwealth Court outlined in their majority opinion that the return trip is part of the business trip. And so they were relying on the case law in Maurer and Oaks to say that the return trip from the business event is still within the course and scope of employment. So if we're strictly applying the door-to-door principle of the traveling employee doctrine, he had passed his home and was no longer within the course and scope of employment.
But could I follow up on the Chief Justice?
Justice Bundy, I think, has a question.
I'm sorry, my question was answered, Chief. Thank you.
Thank you.
Could I briefly follow up on the Chief Justice's question with regard to that exit comment by the Commonwealth Court? I also don't see how that accounts for the possibility that he was simply traveling to a gathering in furtherance of his employer's affairs. And it suggested to me an entirely gratuitous comment, just as gratuitous was the comment that his wife was out of town and that his children were home. I mean, what does that possibly have to do with the question before us, which was whether this event was in furtherance of his employer's affairs?
The underlying case law on the application of a traveling employee doctrine is highly factual. And you can see that when reviewing all of those cases that the facts matter. And I understand that this court isn't here to rule on the facts, but in application of the law, the facts do matter because work activities and business relationships are not, clear cut, and bright line rules don't always apply. So it was really important to consider all of those facts. And so when reviewing the underlying case law, the Commonwealth Court noted that a distinction was made that the return trip was part of the business trip. The return trip had ended.
Do you agree with me that if we determine that this gathering, the Tilted Kilt, organized by Mr. Cintron, apparently, was in furtherance of Centos' affairs, it doesn't matter if he drove past 10 exits. It doesn't matter if there were 20 kids at home or if his wife was in Madagascar. You agree with me?
I don't think that I agree with you, because I think that the WCAB found the facts and they're not on appeal. And the facts that were found were that there was no material benefit to the employer. The appellant went because he wanted to go. It was voluntary. It wasn't mandatory. There were no work-related discussions. It was just chit-chat and wind down. So
are you suggesting we prescribe a test that the WCJs have to go out and measure whether there's a material benefit to an employer or not? How are they going to possibly measure that?
By looking at the facts of the case, whether there's a material benefit to the employer is based on the appellant's testimony and the employer witness testimony. And in this case, you take all of those facts, you add them together, and you come to the deduction that there was a material benefit to the employer.
I think the very purpose of these types of gatherings, not a material benefit, but an intangible benefit, as some of my colleagues have suggested in their questions. Building collegiality, for example.
I don't dispute that that's certainly a possibility, but that wasn't the case here. There wasn't any evidence or finding of that.
Thank you. Any other questions?
Chief, can I add, this is Justice Barrow. I just want, just very quickly, you mentioned in your oral argument, Mayor, which was a Superior Court case, and Oaks, which was a Commonwealth Court. Were they correctly or incorrectly decided in your estimation?
In terms of the ultimate holding or the rationale?
I don't care.
Okay. Mauer, I think, was decided correctly because, as I outlined in my brief, Mauer was a fatal claim and he was deceased, and there was a reliance on this Wolfenbarger presumption. Oaks, similarly, I think was found properly because he was on his return trip home from his business events.
All right. Thank you for that very much. Chief Justice, thank you.
Thank you. Thank you, both counsel. That'll conclude argument in this case. We'll take up the next case in 5 minutes.